If you look closely at South Africa's land ownership patterns today, you will notice that very little has fundamentally changed since 1994. The same concentration of land remains in the hands of a small minority, and most of the population continues to live with the social and economic consequences of dispossession. What's often misunderstood is that this isn't just about slow government programs or lack of funding. It is a structural limitation baked into the Constitution itself. Section 25 was designed with good intentions to protect against arbitrary seizure and ensure fairness. But over time, the interpretation of just and equitable compensation has leaned heavily toward protecting market value rather than historical justice. That means the very clause intended to guide fair redistribution now functions as a brake. When you combine that with the state's weak institutional capacity, each expropriation effort turns into a prolonged legal battle. So, even when political will exists, the legal framework keeps the state cautious, and in that caution, inequality becomes self perpetuating. The deeper issue is that a constitutional safeguard has evolved into a constitutional barrier. The moral weight of property rights has overshadowed the moral necessity of redress. The law's precision, which was meant to preserve fairness, has created paralysis, locking South Africa into a version of economic inequality that can't be meaningfully corrected through incremental policy tweaks. In practice, this means that decades after democracy, access to land and therefore access to generational wealth, stability, and autonomy remains largely inherited rather than earned. Every missed opportunity to address that imbalance deepens the divide between those who own and those who serve. Without adjusting the constitution to prioritize equity as much as property, South Africa is effectively legislating stagnation. The intention to avoid chaos has produced an equally dangerous outcome, a permanence of imbalance.